afternoon.
Thank you.
I hope the arrangements are
all fine.
good.
I wouldn't say she's happy about it, but she'll be fine. It's only a couple of hours to go. My lords, I am here from the Secretary of State with Mr. Kozelko.
Yeah, I think we know that.
I'm going to address you on the carbon emissions and greenhouse gas grounds, and Mr. Kozelko is going to take wastewater treatment. And I'm going to take grounds in order.
Right.
So, what was ground 1 in the High Court, then on CO2.
Can we, just as a matter of, can we just stick to the numbering in the High Court? I've got used to that now.
Yes, that's ground 1, ground 3, and ground 4.
Yeah.
In that order, in numerical order.
Thank you very much.
Straight into ground 1 then.
Yeah.
I don't have much value to add to what I say is a detailed and considered judgment. All the analysis is there and the judge's conclusions are right. So what I'm going to do is take you briefly to IEMA,
Yes.
then the decision letter, and then the judgment. And I don't think this will take So you have in writing from us how we say the IEMA guidance works in our skeleton, and that is, as the judge also said, it is practical guidance aimed at those who are in the business of preparing and drafting environmental statements. I can show you some bits of IEMA that support that submission. They're also in the judgment at paragraph 184. We go to the supplemental bundle, page 89, that's behind tab 7 in the hard copy.
So, yes.
And I'm on page 19.
90.
I always do this. It starts on page 89, but I'm going straight to page 91.
Right, thank you.
It's paragraph 1.1 if you're there. The aim of this guidance is to assist GHG practitioners with addressing GHG emissions in EIA. You then, moving on, going through the extracts from the guidance to page 95 of the chapter on significance, chapter 6, again with an introduction which sets out that greenhouse gas emissions are very important. Any greenhouse gas emissions can be significant.
That's 6.1, is it?
That's in 6.1. And on the right-hand side, there's an explanation under the bullet point. The guidance in this document provides further detail of how principles can be applied, particularly how the net effect of a project and its beneficial or adverse effects can be evaluated in the context of emissions reductions on a trajectory towards net zero. Over the page, you have, on page 96, what is described under 6.3 significance principles and criteria. And that explains further explanation on different levels of significance. It needs to be read in conjunction with figure 5, and that's the box setting out major adverse, moderate adverse, and minor adverse. And as you can see, that box shows that there are different shades of adverse.
It's a spectrum.
It's a spectrum, exactly. And that is in many ways the answer, part of the answer to this ground, is that even when you're in the territory of incompatible with the pathway to net zero, there is a multicoloured spectrum. If you go over to box 3, you then have the narrative explanation of what that diagram looks like. On page 98, these are examples of significant criteria. So again, they're an aid to decision making. Judgment still needs to be used. And you see moderate adverse. It talks about projects' impacts being partially mitigated, partially meet the applicable existing and emerging policy requirements, not fully contribute to decarbonisation.
So, just going back to the top of box 3, when it says line 2, major or moderate adverse effects, beneficial effects considered to be significant, that's in the context of EIA legislation.
Yes, that's in the context of EIA. That's exactly what this guidance is. It's trying to help practitioners
apply the regulations so far as climate change is concerned.
And articulate what significance is in circumstances where, as Finch says, it's a concept that doesn't lend itself to particularly granular definition.
So we've got the definitions of major, moderate and minor.
Yes. And then page 99.
The difference between moderate and minor being the difference between not fully contributing to decarbonisation in line with etc., as opposed to being fully consistent.
Yes.
And significance appears to be to hinge on whether it is major or moderate or not.
Yes. And so when you look back at the description of significance as meaning something that's incompatible with the trajectory, or whether it's consistent with the trajectory, which you get at the top of page 96, you need to look at that in the context of the rest of this guidance, which is saying, as you say, that there is this range and there is a scale and it's about shades of compatibility. It's not a binary. Incompatible in this guidance means you're going to breach carbon budgets if you grant planning consent for this project. On page 99, under the heading Contextualising a Project's Carbon Footprint, I just want to draw your attention to the second sentence of the first paragraph. Determining a trajectory and position for project within it, however, is a challenge. And the next line, it's down to the petitioner's professional judgment on how best to contextualise a project's greenhouse gas impact. And that, in my submission, goes to the general tenor of this guidance, which is we're trying to help you here by providing a bit of specificity and some examples, but a lot of this is down to professional evaluation and judgment. It's also important, in my submission, that IEMA is aimed at all sorts of projects. It's not aviation specific, it's not even NSIP specific, and that's also a point that was made by the judge. And that's important because different projects will have different trajectories of emissions. You have here a project, and I'll show you this in the decision letter in a moment, where greenhouse gas emissions were being emitted, but they would be mitigated long term. You could have the converse kind of project where it's all fine for 20 years and then suddenly you've got a big peak at the end. And there is a question as to how a decision maker plots that onto this multicoloured box on page 97, and that is a matter of judgment and evaluation. So with this background, we then go straight to the decision letter.
Just before we do that, I've read somewhere that when dealing with non-CO2 GHG, if you're looking for contextualisation, there is guidance in IEMA, and it would be, I imagine, to be found in 6.4. So I looked through 6.4, and as I understand it, the paragraph which is relevant is on page 100, right-hand column, second paragraph.
Yes, where quantified carbon budgets or a net zero trajectory is lacking, a more qualitative or policy-based approach to contextualising may be necessary in these instances. And that's a point I was going to make under the next ground.
Yeah, but just whilst we have the document in front of us, yeah.
That even IEMA says when you've got something that can't be compared to a carbon budget, a qualitative assessment is appropriate.
Because when we come to the carbon budgets, they're expressed in CO2 equivalent terms.
Yes, and they don't include non-CO2 emissions.
Even though they use the word equivalent.
Yes, correct.
Right.
What the CCC is doing, just to continue this thought for a second, and we'll come back to it.
Yeah.
In that document you were taken to by the CCC's advice on carbon budget 7, is saying, well, we think we should include non-CO2 in our analysis of the balanced pathway, which is their own route for getting to
net zero.
And to net zero.
Yeah.
But it's not the government's route, because the government's route is set out in the CDG.
The government was due to respond to that in June 2026.
Yes.
No
I
doubt
don't know
they,
if it has.
but whether they have or haven't, it's way after the decision letter.
Way after the decision letter, and the government's it has long been the case that the government disagrees with parts of the CCC's analysis.
Oh, yeah.
And one of the bits it often disagrees with the CCC on is demand management for aviation, which was part of
But we can't really go there. Okay, thank you. That deals with page 100 then. You were about to move to the decision letter.
Yes, so straight to the decision letter to what was decided. So page 172 of the Common Bundle at paragraph 201. So this paragraph is resolving a dispute with the examining authority. So again, just as a matter of context, because it was mentioned in submissions by Mr. Hon, what the examining authority did was they looked at the emissions from the airport as a whole and not the emissions just from the development. And that's what led the examining authority to their conclusion on significance. So the reason why the examining authority's conclusions were not agreed with in this case was because of their approach and the way they calculated the impact of the scheme. So that's just a bit of background and why I'm taking you into 201, because what the Secretary of State then says is, I'm going to assess significance on the basis of the proposed development's contribution to carbon budget 6. And that is 0.6557%. So she's got the number there that she's working with. And then she flags at the end that she's going to give an overall consideration of significance below, and then she works through all the different factors. Paragraph 203 just makes the point that, reflecting on EMA, that it all needs to be considered in the context of existing and emerging policy and legal requirements. Paragraph 204, she makes the point that approximately 95% of emissions are attributable to aviation. In this scheme, these are regulated at a national and international level, with potential reductions driven by a range of national aviation policy statements and activities, including the high ambition scenario and the TDP. And then, this is important, the Secretary of State therefore considers that over time, the net carbon emissions resulting from the proposed development's operation will decrease as measures to reduce emissions from aviation are delivered. So that's the sort of peak and then trough that I referred to. She is then trying to take that profile and that impact and plug it into her assessment of significance. Paragraph 210 is the key paragraph. Before that, she goes into non-CO2 emissions, which we'll come back to. And mitigation. So 210, she says, regarding significance, the Secretary of State has considered box 3 of the EMA guidance, which provides practitioners with examples of how to distinguish different levels of significance. If I could ask you just to read the rest of that paragraph, I'm sure you've already read it.
I think we have.
Yeah, we have, of course. I'll just make submissions on it. Mr. Hon skipped over it, but it's actually very important. The Secretary of State makes it clear that she's looked at 3. This is also not just her assessment of quantifiable emissions, she's also drawing in non-CO2 emissions. She says there's going to be an increase in GHGs, carbon and non-CO2, and then she relies on the scale of the effects. These would fall short of fully contributing, so that's the language of moderate. It was said in submissions that it wasn't clear what the Secretary of State
Well, it didn't use the term moderate, but since
Doesn't
it's clear what it's saying.
Yes, it didn't need a pat response to confirm it, so there's no error in the reasoning there, or inadequacy, although this would be mitigated in the long term. So that's not, she's not saying this is incompatible with the trajectory to net zero. It's a more nuanced conclusion, which is something the judge recognised, which is there is an increase of a scale that's not fully compatible, but it will be mitigated. So that's her conclusion on significance. Paragraphs 211 and 212 are then the acceptability part of the analysis for the purposes of national policy. So having identified that, this is her integrated reason conclusion.
Sorry, you're at
211.
Yep, thank you.
So she refers to 5.82 of the NPS. She refers to the number in terms of the contribution to the carbon budget from the emissions that have been quantified. She then goes on at 212 to say she's satisfied it's compatible with the Jet Zero strategy, can be managed within net zero, and so not materially impact the net zero targets. And as such, it's not major significant in our terms. She gives it moderate adverse weight. And it's not a reason to refuse consent on its own, which is the ANPS text. So on its own terms, that all makes perfect sense. There's a clear explanation from the Secretary of State of what factors have fed into her assessment of significance, the fact that she's found it significant adverse, and what she means by significant adverse, which is not fully contributing but mitigated over time. And then she's put that into her analysis of the planning policy. And that is, in my submission, all fine and all very clear. A problem only arises if you say, as the claimant does, that by applying the IEMA guidance and by adopting and by following that through to get to significance, incompatible in IEMA terms means in this case not consistent with carbon budgets or a material impact on carbon budgets.
Well, it means non-compliance with 5.82.
Yeah, non-compliance
with the
5.82.
ANPS, because it will materially affect the ability, etc.
But the Secretary of State asked herself that
Where's the
question.
non-compatible in the IEMA again?
That is in 6.1, in the narrative bit of 6.3.
Yeah.
And that is on page 96. So there's a text in bold. The crux of significance is not whether a project emits GHG emissions, nor even the magnitude, but whether it contributes to reducing emissions consistent with a trajectory towards net zero. And then you've got on page 97 more detail under 6.3.
It's consistent with, so or consistent with, compatible with.
Yeah.
And then the next one?
So yeah, significant adverse is not compatible with UK's net zero trajectory or accepted aligned practice for area-based transition targets.
Yes. But that's an umbrella term which covers both major and moderate. Yeah. It's not really meant for lawyers to apply.
Problems always seem to arise when lawyers get involved.
Well, sometimes.
So certainly I've had to do a close textual analysis of these pages before you, my lord, before.
Oh.
In Boswell, Secretary of State for Energy Security and Net Zero.
Anyway, that's that.
So that's that.
Was that the decision letter then?
That's the decision letter. There's no logicality in the decision on its face. It's all very well explained. It's only if you take the IEMA guidance so literally and don't recognise that there is these shades of significance that you end up with, and in my submission that problem just doesn't exist. This is then all very clearly analysed in the judgment. There's lots of detail in there. It's paragraphs 196 on to paragraph 210. And as I said at the outset, it's very difficult to improve upon that analysis. It's all there, and the judge didn't make any errors in the way in which he reasoned it through. There is one point remaining, which is that the appellant relies on the Boswell case and paragraph 70 of the Boswell case. And the judge distinguishes that at paragraph 211, and it said that that attempt to distinguish it isn't good enough. By way of background and explanation to the Boswell case, that's a project for a new gas-fired power station and carbon capture and storage. The point in that case was that the project generated quite a lot of CO2, but it was designed to assist in the transition to achieving net zero overall because it was a first of its kind CCUS scheme, and the policy in that case was that these kinds of schemes are urgently needed to assist in the transition to net zero. So the question there was between, if you find it significant, which actually in that case the Secretary of State didn't apply any guidance at all, but what the Court of Appeal said, well, if you had said this is not consistent with the trajectory to net zero, and at the same time had your need case say this is needed to assist with net zero, then that is obviously a contradiction. That's not actually what the Secretary of State in that case decided, and it's different from this case, where the Secretary of State was applying AIMA in the way it was intended to be, by looking at the grades of significance and reasoning through why, yes, it's significant, but not so significant as to hinder compliance with carbon budgets.
Just looking for, the judge dealt with this in 211.
Yes. But there's a similar species of argument in Boswell, which is because you mentioned AIMA, you must have meant significant means not compatible with net zero, and that doesn't make any sense because of other features of the decision matter.
Sorry, which decision there, sir?
In the net zero case.
Right. In the Boswell case.
Yeah.
So which paragraphs in Boswell should we look at?
If you look at paragraph...
This is volume 2, is it?
Yes, it's volume 2, tab 36, page 1354 is where it starts.
If it's tab 36, I think we need
Was that not volume
3.
2? I have written down all the volumes.
But it is tab 36, isn't
Yeah,
it?
it's tab 36.
In the Court of Appeal, yes.
Yeah. If you read paragraph 68 through to paragraph 70, you should get the background to
68 to 70.
68 to 70. They will come flooding back when you do.
Wouldn't bank on it.
Judgment of the
So your submission is that 70 is to be read in the context of 68 to 69.
Yeah. So 68 encapsulates the policy issue there, which is why we and the judge say that the policy context was different and why that's important in this case. Because you had a policy that says in terms of this type of development helps net zero, or helps achieve net zero.
How does that help to distinguish 70?
Because in that case, the alleged illogicality was you can't grant consent on the basis of a need, an urgent need for this development to assist in the trajectory for net zero, if you have also found, in AIMA terms, that it is incompatible with the trajectory towards net zero. That makes no sense. That's not actually the error.
It's not the same error as here.
It's not the same error that's alleged here. And it's not actually the error in that case anyway, because the Secretary of State didn't use AIMA. So it was part of the court's explanation as to why the appellant's case didn't work.
Okay.
And that's it on that ground knowledge, unless I can help with anything else.
No, thank you.
On then to non-CO2 emissions. Just to ground ourselves, the legal obligation here under the EIA regulations, which I don't need to go to, is to describe and assess the significant effects in an appropriate manner. That's regulation 5. It's well established that that involves an element of judgment. There is certainly no express legal obligation to quantify, or even an obligation that when faced with a choice between quantification and a qualitative analysis, you have to pick quantitative. That's no part of the regulations. So in this case, when it came to what to do about non-carbon dioxide emissions, the Secretary of State was left the question of how she should go about assessing in an appropriate manner. That is a question of rationality. That is the question of whether it's asking yourself, was what the Secretary of State did rational? And that's how it was analysed in the report below. There was some suggestion in the skeleton for today, but I think it's no longer pursued, that the Secretary of State just failed to identify non-carbon dioxide as an effect, but that's not the case. It's been pursued orally, and it's not right anyway. I think that's been abandoned. What was said orally is that in order to comply with regulations, the precautionary principle requires the quote-unquote best scientific evidence. It's very unclear here what the appellant is saying the best scientific evidence was. I don't think there is a particular methodology or multiplier being advanced as the best scientific evidence. Brackets, we'll come to the CCC in a second, because that was the main bank of the submissions you've heard today. It seems to be more that some kind of quantification was required.
I think the start of the submission is what the Secretary of State said at the start of the paragraph, where she deals with this and says, "I'm disappointed that there wasn't." Yeah, that's the starting point, not the points you're on now.
Yeah. But that is, I make those points because it's part of the tram lines we're operating in. We're looking at, was the judge right to analyse it the way he did, and is there any arguable basis to say that what the Secretary of State did was irrational? And then I will come to that half line in the decision letter very shortly. In asking whether what the Secretary of State did was rational, there are a couple more elements of these foundations or tram lines. One is the law. Both the Applicant and the ban case endorse a qualitative analysis as rational and compliant with the IA when it comes to non-CO2 emissions on the basis of acknowledged uncertainty in how they contribute to global warming. Yes, it is thought that they contribute more by way of warming, but those can be short-lived or more short-lived than carbon dioxide emissions. And so there is difficulty in assessing their impact.
Right, this is non-CO2 emissions from aviation. There can be more of them, but they can be more. They in that context can be more short-lived.
They can be more warming in their effect, but they may last less time. So there is. I'll dig out the reference for you. In one of the documents, I think it may be the CCC's advice. It refers to non-CO2 sometimes lasting 10 years, or lasting around 10 years, whereas CO2 lasts decades. More lasts much longer. And so that's part of the uncertainty issue. Is that non-CO2 is more short-lived in its effects, even if it may be greater in its warming power.
What's said about Applicant and Barn is that I think they both predated the two additional pieces of evidence upon which this argument is based.
And I'm coming to that.
Yeah.
I then have just some very brief points on that's what the law said, or what the law was at the time of the decision, certainly. Was out at the time of the decision. There's then a question of, well, does policy make you do it? When you're thinking about
you're talking about the law. Is there a good statement for the purposes of this issue, in this case, about the precautionary principle? We were taken to Wyatt.
Yes, the precautionary principle is addressed in BAN. Find it. So that is in the authority. So this wouldn't be referred to the authority. BAN is in the authority bundle at 27. And it's page 1005 and 228.
228.
So it's a reference back to Friends of the Earth, where there was an argument that the AMPS ought to have accounted for non-CO2 emissions.
No, what I was looking for was something to do with handling scientific uncertainty.
I think that's Wyatt, isn't it? What say before it.
Yeah, well, that was what we were taking to this morning.
Yes, you're taking to Wyatt, but that Wyatt is a habitats case.
Yeah.
Well, precautionary principle is very important in habitats cases too.
It is very important, but that's a specific issue, which is where you are faced with scientific uncertainty, you resolve the uncertainty in favour of finding an adverse effect for purposes of the habitats regulations. Here, the point that's being made by my learned friend is what the precautionary principle requires you to do is use the best scientific evidence. I don't really have a problem with that as being a proposition.
Not to arrive at the decision you take under the habitats regs, but for the purposes of actually making an evaluation.
Yes, is that best precautionary principle requires you to look at all the evidence. What we don't have here is then the link that what happened in this case, and what the appellant is saying needs to happen, actually represents the best scientific evidence. So I don't think there's a legal issue to be resolved here, or what the precautionary principle requires, and that's what the judge said in the court below. The precautionary principle doesn't really add anything. When you actually look at all this material, it doesn't tell you that the precautionary approach is definitely to apply X multiplier against Y benchmark. So with that, it makes sense to take you to probably the decision letter first. And then I will come back to, in fact, I'll stick with the way I was going to do it, which is that the debate about non-CO2 emissions was before the examining authority. It's dealt with at page 58 of the Common Bundle at 8.4.17, on page 58.
Sorry, 8.4.17.
17.
Thank you.
And this is where you have a summary of the various different multipliers that parties were referring to in the examination. So you have the multiplier of 1.7, which is the DESNES guidance in that paragraph. You then have NEF referring to the Department for Transport's aviation unit saying it can be defined as a sensitivity test in the socio-economic assessment. You then have a different set of interested parties at 8.4.19 suggesting other multipliers. You then have the applicant's position at 8.4.22 to 23, where the applicant says it's also uncertain. A multiplier of 1.7 has to be seen in the context of significant and acknowledged uncertainties. And then the point at 23 that even if you quantify it, what do you then do with that number? Because there isn't a benchmark, because it's not included in the carbon budget. But that they've got measures in their carbon action plan to continue monitoring and doing further work as emerging policy comes forward.
You've also got at the end of 8.4.20, in Cagney's case, the lack of a settled methodology, that sentence, which
Yes.
I think was picked up by the examining authority.
Yes. I'm getting to their conclusion.
Yeah.
And again,
But when we
that's-
talk about the multiplier, take the 1.7 and 8.4.17. What do you multiply? Presumably, if you've got a certain a certain quantity of CO2 emissions, you apply the multiplier to that.
And that becomes a CO2 equivalent, presumably.
it becomes CO2 plus non-CO2.
Yeah, but I mean, you're trying to convert the non-CO2 into a common currency with CO2, presumably.
There's some
That's what I
nodding and
think.
some
I might
head
be wrong.
shaking.
There's quite a lot of head shaking, and I'm happy to know precisely.
Well,
That's my understanding.
this is part of the difficulty of what I was saying earlier. The difficulty of this court trying to engage with what is a very significantly complex technical and scientific exercise. And that isn't what this process is designed to engage with. What it's designed to engage with is whether or not there's an error of law. And the error of law here, it seems to me, what is contended for, is the omission from the environmental statement in breach of Regulation 21 of this type of emission. So, going into all the technicalities of how one person might do it or another person might do it is context, but it's not the legal point that we've got to think about.
It is the legal point, my lord, because what is being said is that the quantified analysis is missing from the environmental statement.
Yeah, that's a question of what's the content of the environmental statement. Is the content of the environmental statement lawful?
Yes. Is it enough?
So this is just context to whether or not it was rational for the Secretary of State to say, I accept an environmental statement in which this is not addressed. Or is only addressed, is addressed qualitatively
that's why
rather than quantitatively.
Yeah. It's not
but it's context for that decision. It's not a question of us concluding that there might be a better way or there might have been a more preferable way of doing it, because we're simply not equipped.
And I'm not asking you to resolve that. What I'm doing is showing you that in the examination there are a number of different multipliers floating around that different parties were advocating, and that in my submission goes to the question of rationality, because this isn't a case where there is, and this is what the judge said, there is one...
Well, look at 8422, which I think is what you were trying to say earlier, a few moments ago.
Yes.
The multiplier is not straightforward.
Yeah.
Equivalent metric, etc. Relative contributions of emissions to climate change over time.
Yeah. So when faced with all this uncertainty, was it rational for the Secretary of State
That's
to
a
say,
conceptual uncertainty, not just putting a number on it, but
yes,
what it actually captures.
yes, and was the Secretary of State therefore entitled to say, I'm going to look at this qualitatively, which is what she does in the decision matter. And the reason I take you to the examining authority's report is because there is a forensic point, which is that after this big debate and the examining authority agreeing that a qualitative analysis was appropriate, Cagney were satisfied with that at that point in time, but their case then became, but matters have moved on since then. And that's where you get the EU ETS and the CCC's advice, where they then start proposing yet more potential methodologies for quantification. And my very brief submission, and I can take you to the documents if it would assist, but it might not, is that neither of those provide a clear and settled guidance which says, when assessing impact of aviation emissions for the purposes of the planning decision, use this approach, which is quantified. None of them say that. The CCC says, we've done it for the purposes of our work, which is what you were taking to earlier today. They don't say anything about planning decisions in that document. The EU is all about monitoring specific flights. The data that would be available to use that analysis doesn't come. There's no reporting obligation to actually do that until March of this year, so it postdates the decision. So what the Secretary of State is faced with is various people saying there are all these different ways of quantifying, but also the applicant saying, but quantification in and of itself is difficult. That's what the examining authority agreed with. And then you have the decision letter itself and the particular sentence or half sentence that the appellant relies on. And if we go to that, the analysis starts at page 162 of the Common Bundle. Where you have a summary and recitation of all the arguments that have happened, both in the examination and then in the post-examination round of consultation. You have at paragraph 175 or page 164 the arguments made by Cagney in its response to the examining authority's report. You then have a reference at paragraph 176 to the AIMA guidance, which points the other way and says if it's difficult, qualitative analysis can be appropriate, We looked at that earlier, on page 100 of the bundle. And then you have paragraphs 177 and 178. And I invite you to read them the whole thing, and then I can make submissions.
I think we have read it.
You have? Yeah. So what the Secretary of State is saying there is she's disappointed that there wasn't an attempt to quantify the emissions, but then she goes on and says she notes there's no established methodology, as cited in BAM, where scientific consensus would guide the quantifying these emissions. She therefore agrees that a qualitative assessment is appropriate in the circumstances and refers back to the examining authority's conclusion. And then also that there are measures coming forward in the future because there's work being done on the policy to better understand and address non-CO2 emissions. And so yes, the Secretary of State has the precautionary principle in mind. She says quantifying it was precautionary, but then acknowledges that there's nothing she could really have done with that number had it been quantified, and it's all very uncertain, and therefore, on balance, she decides a qualitative approach is appropriate. So that is, in fact, an example of working out of the precautionary principle, is she's trying to do her best when faced with quite significant debate on the very technical matters in the examination and post-examination submissions. Guidance both ways from IEMA and from these other bodies that have put forward their multipliers and their approaches. And she's got to come to a judgment as to which to do. And the judgment she ultimately lands on is that qualitative is the right answer for these practices. And that, my lords, is what the judgment says at paragraph 260 on page 288 of the same bundle.
What was the reference again?
Paragraph 260 of the bundle and 261. So stepping back, my lords, and asking what was rational, given all of those foundations that I was keen to emphasise to you, and given what happened on the facts in the examination and subsequently, it was obviously rational for the Secretary of State to proceed as she did, and for her to explain what she did in the way that she did. And to the extent that there is any issue of the precautionary principle here, as I said before, there's no legal issue about what it requires. What the appellant says is you needed to use the best scientific evidence, even on that analysis. There wasn't best scientific evidence here. That's the obvious conclusion of what the EXA and the Secretary of State said in their judgment on the scientific and technical matter. There wasn't one multiplier, one methodology, one benchmark.
No, I mean, I think what's said against you is if the precautionary principle is in play, what it also requires is if you cannot find an answer to something which gives rise to a likely significant effect, then the answer you should alight on applying the precautionary principle is that it will be harmful. Not that you're not going to try.
But that's what the Secretary of State does. She says, I'm doing a qualitative analysis. I accept that they have a net warming effect and that they contribute, but they're not tipping my assessment of significance into major significance. And they're not affecting my planning decision that I should refuse on the basis of non-CO2 emissions.
So on that analysis, what you're saying is she did have regard to the precautionary principle and applied it faithfully by assuming in the absence of scientific certainty that there will be an adverse effect, which is what the precautionary principle means.
Yes, exactly. And that's why there's no error. And that's what the judge said in the judgment. So why the ground of appeal has no guilt to this. Oh yes, I've got a note for you on my 10 to 20 years point, which is it's in the notes in SB 307.
That was the extra page
Ah yes, it is the extra page.
from the CCC
Yes.
CV7 report. And it's okay, just above the bottom hole punch.
Yes. So fresh, that's why I was able to remember it. So note 2.
Thank you.
That is non-CO2. Then on to ground 4, which is the delivery risk ground. There was some debate this morning about what the appellant's case is and what the Secretary of State's case is. If I can take a moment to clarify what our understanding was and what our position is, hopefully that will assist. This was pleaded in the Statement of Facts and Grounds at Core Bundle, page 70, as a rationality case. So if you turn up the Statement of Facts and Grounds, it starts with, I mean, you can see the heading there, failure to take into account material risks and or comply with the duty to make inquiries and or a rational approach to the JZS. So you get it from the heading, you get it from the legal principles that are then cited, which are all about material considerations and team side. And then at paragraphs 73 to 80, you have the submissions about why it was irrational not to take these into account.
Sorry, is that? Oh yes, I'm with you.
So paragraph 76, 77 through to 80. That's how the judge analysed it. It was presented today as more of an EIA, ES issue, and possibly a closed mind issue. In my submission, if it's an EIA, ES issue, you're still looking at standard of rationality, so I don't think we need to get into or spend much time on precisely what the nature of the error alleged is, because for my purposes, I just have to show you that the judge is right, that there isn't an irrationality point here. It's not a closed mind case. The decision letter doesn't say, I can't legally look at delivery risk. The underlying material in the Secretary of State's position in the High Court and in the witness evidence is that given Section 30 operates in the way that it does, and given global feedback, that is a reason why I didn't go ahead and look at delivery risk. It's not saying you're legally prevented from doing it, it's saying that's part of the relevant context as to why it was rational not to. I will explain, I think I'm going to have to explain.
Well, yes, I think
but that
only goes some way to explaining, because there's one scenario that was a positive decision taken by the Secretary of State. On another scenario, I didn't take it into account, and my ex post facto explanation for that was I didn't need to do so anyway, both of which could be perfectly reasonable, but I think the point that was being explored earlier was do we know which of those it was?
And to assist you with that, the Secretary of State's position, which you get from the decision letter, I'll take you to in a second, is delivery risk or uncertainty in the high ambition scenario was taken into account as a matter of principle. So the fact that it's
as a matter of principle.
Yeah, so the fact that it's uncertain, so at a high level, put it that way, the fact that it's uncertain and difficult was taken into account. And I'll show you the decision letter where that is. The 1 year on modelling point was considered by the examining authority and refers to, by way of a cross-reference to the examining authority, in the decision letter. It is common ground that the Secretary of State didn't, when undertaking this planning decision, go away and look at the Commission return. That is common ground. We did not do that.
Nor were given any briefing.
Nor given any briefing on it. And the Secretary of State's position is the reason why that happens, which is explained in this Matthew statement, is because that is modelling carried out for this different purpose, which is the Section 13 exercise. And we say, therefore, what this is really a case about is, having acknowledged delivery risk, having acknowledged uncertainty, was the Secretary of State rationally required to do more than she did in the decision letter? And that is a good point at which to look at the decision letter and what was actually said. So if we go straight to the DL at paragraph 156, which is on page 160, you have there, so this is a section setting out how the applicant went about assessing carbon emissions. At the top of paragraph 156, the applicant considered it as appropriate to rely on the Jet Zero high ambition scenario as it represented current government policy on aviation. There's then a submission by GAC, which says that the high ambition scenario is not the worst case. Secretary of State acknowledges that there is uncertainty given the JZS includes reliance on new and emerging technology, but notes paragraph 1.10 of the JZS, which sets out that the government is committed to the high ambition scenario. The Secretary of State agrees with the applicant and the EXA that it is reasonable to adopt this approach. So she's specifically addressing her mind there to, yes, it's uncertain, but I think it's reasonable to adopt the high ambition scenario. At 157, in recognition of this point, the applicant actually submitted a sensitivity case which showed a slower fleet transition scenario. So what if the ambition in the Jet Zero strategy is not achieved at Gatwick? So that's newer aircraft not being brought into service as quickly. And you see there's some detail about what that does in terms of the magnitude of carbon emissions. So it changes it from 0.578% under the high ambition scenario to 0.586%. So there's a bit more information there for the Secretary of State as to what the impact of uncertainty in the Jet Zero scenario might be. Now, I'm not saying it addresses all the uncertainties, but there was a sensitivity analysis there. And then we turn over to paragraph 166. Where there's a reference back to concerns from interested parties about uncertainty surrounding the means to achieve the objective of JZS. She notes the examining authority's view that the policy is robust and there are mechanisms to review and adjust the policy as necessary. There's then a cross-reference back to the examining authority's report at 8.4.11, 8.4.11. If you have one finger in the decision letter and flip back to the examining authority's report on that point, which is on page 57, you have a reference there to the submission from Cagney that you were taking to today about the impact of the 1 year on modelling. So it's something the examining authority thought about. And talks about modelling on which the JZS is based subject to detailed integration of the RPs. The policy itself is robust. Consequently, there's no reason why the weight should be reduced. And that's a conclusion the Secretary of State that is what we understood the issue to be, is that the Secretary of State acted irrationally in giving full weight to the high ambition scenario, because she didn't take into account the more detailed delivery risks that have been articulated in the Commission return and the modelling issue in the 1 year on strategy. Now, to answer that, the 1 year on point, that's something that was considered by the examining authority. It's not something that's been left out of account, it's not something that's been ignored, it was considered, it found its way through into the decision letter and formed part of the analysis. So that's a headline answer to that bit of this round. There's a bit more to say about the modelling itself. I might leave that for Gal to address you on the detail of. But in terms of the Commission return, it's again important to understand the relationship between the Jet Zero high ambition trajectory, what the Jet Zero policy says, and the Commission return. Because that's all important context to whether the Secretary of State was entitled to rely on her policies, which are still government policy, have survived legal challenge, doing what they're supposed to do.
So it's the relationship between the high trajectory and what was the second point?
Policies which have been
Return.
established.
So yes, you need to understand what the JZS says and what the high ambition trajectory is before you then look at
So the relationship with the policies and the JZS?
Yeah.
Thank you.
So, the first point, which is, again, foundations and background, the law is that when making a planning decision, the Secretary of State is rationally entitled to rely on her non-planning policies delivering the outcome that they seek to achieve. That's in the Dawes case, it is also part of the A12 decision. Secretary of State is also entitled to rely on Section 13 of the Climate Change Act machinery operating as it is designed to do. So that's the starting point for the rationality analysis. The second point then is, on the facts of this case, what's the high ambition trajectory? If you go to the JZS, which is in the supplemental bundle at page 516, which I think is at the back of your bundle, where pages were added. Common bundle. You have the forward.
Can I have the reference again, please?
It's Common Bundle 516.
Thank you.
So right in paragraph 1, at the very beginning of this policy document, it says in terms, our target of net zero flying by 2050 is hugely challenging. So there is an acknowledgement that what the government is trying to do is difficult. Then it goes on to explain that they developed, this is the second paragraph, they developed a jet zero strategy in order to both secure a sustainable future and boost trade. The strategy is underpinned, this is the third paragraph, by an overarching approach and 3 principles. So they're setting a goal, which is net zero by 2050, and all domestic flights net zero by 2040. And then we will be setting an emission reduction trajectory for the sector and will be monitoring progress through the 5-yearly reviews. So what the high ambition scenario is a trajectory for checking progress. It's not a specific pathway that the government must follow in order to reach jet zero aviation by 2050. There's more of an explanation at page 520, which explains what the high emission scenario is, which is bottom left-hand paragraph.
So page
520. So there is CO2 emissions trajectory that sees aviation emissions peak in 2019 and then start to come down. And it sets there the figures for what the in-sector targets are by 2030, 2040 and 2050. And on page 522 on the right-hand side, it talks about monitoring progress against the trajectory on an annual basis, followed by a major review of the strategy every 5 years. And this is the bit that the decision letter and other parties refer to when they talk about measures in the Jet Zero strategy to deal with uncertainty. And it says, we recognise many of the technologies needed to decarbonise the sector at an early stage of development, and therefore we've committed to reviewing our strategy every 5 years. We'll use them to take stock of how emerging technologies are developing, whether they're developing at the pace required, and if they're being adopted by the sector. And if we find the sector is not meeting the emissions reduction trajectory, we will consider what further measures may be needed to ensure that the sector maximises in-sector reductions to meet the UK's overall net 50 target, net 2050 net zero target. So built into the policy are review mechanisms, a commitment to bring in additional measures if they are necessary. And all of that is there to address the acknowledged fact that there are delivery risks to this policy because it's all very nascent and early stage and it's going to be jolly difficult. We then have the 1 year on analysis itself. So you take into the extract from the modelling that was provided in response to freedom of information request. You've got the 1 year on, which is a bit earlier in the bundle at page 459. That same bundle.
Sorry, page
459.
Yeah.
And what this document contains is some good news about how the government is performing against its target. So it acknowledges that there are successes, but still acknowledges that it's all hugely challenging. And you see that on the left-hand side talks about significant progress, and then there are 3 bullet points. And then the right-hand side talks about still so much more to do. Achieving Jet Zero is hugely challenging. So when the Secretary of State is thinking about whether or not to give full weight to the Jet Zero policy, whether the trajectory is an appropriate trajectory against which to assess emissions, all of this is part of that background, and all this is something the Secretary of State knows. She knows, because she refers to these policies in the decision letter, what the progress has been, that is hard, that it's challenging, and yet still exercises her judgment in the way she does in the decision letter. We also have on 466 and 467 an update on how they're doing against the high ambition trajectory. And there it's a cautious good news story, which is that UK aviation activity remain below 2019 levels. That's largely due to COVID.
Sorry, one of the things about these documents is they don't have any paragraph numbers.
So it's the
They're not very user-friendly. So where do we find this?
I'm finding this in, you've got a bold paragraph, and then it's the second not bold paragraph, where it talks about
The
progress.
latest data.
Yeah, latest data, progress against the emissions reduction trajectory. And that, as at the date of that document, they're still, this is the very bottom in bold, 29% below 2019 levels. Where they want to be.
You've been giving bundle numbers, which I'm afraid I don't recognise, but I am on the right document. I just want to make that publicly
I
clear.
think there are two versions of this. I think there's some.
So I'm looking at page 466
Yeah.
of the common bundle.
Yes, that's right. That's right.
I can see nodding. I have not gone mad. That's very
Yeah, that's
reassuring.
Possibly I jumped. Well, yeah, I might have
Don't
skipped it
worry.
quickly. And then you have the other reference I want to teach is 474. This is just on sustainable aviation.
But you said 467 as well. Is there anything on 467 we need?
I've got that in my note. That explains that the scenario has been updated to reflect the latest macroeconomic conditions. The impact of that is reduced passenger demand growth in the high emission scenario and lower residual emissions. So again, it's from the government's perspective, doing well against the high ambition trajectory.
So then we would go to 474.
474, which then...
I mean, the last point you've just touched on was the second of the 2 points being put before us under this ground this morning. Oh, no, but this is not Gatwick specific. This is aviation. Yeah.
This is reasons why the Jet Zero strategy
Yeah.
can rationally be reliable.
No, forget that.
As expressed.
474 then.
And then 474, and this is just to illustrate the flexibility of the Jet Zero strategy. This is about sustainable aviation fuel delivery, and it's the text on the right-hand side. So it talks about achieving 40% of emission savings through sustainable aviation fuel, and what the mix of that is, 33% by efficiency improvements at zero-emission aircraft, and 14% by reduced demand, and 13% by greenhouse gas removals. And then it's the second paragraph, second line. Unsurprisingly, given the complexity of decarbonising the aviation sector and high levels of uncertainty, the contributions of individual measures do not align exactly with those implied by our modelling. And then it gives the different numbers. And then we'll continue to work with industry to identify challenges and barriers they need to overcome. So again, that's the measures in the Jet Zero strategy to address uncertainty in action, working away to keep the government on track to meet its overall goal. So delivery risk policy, the Jet Zero high ambition strategy, is considered in formulating the policy itself, because it's right there on page 1 of the document, in reviewing the policy, and then also by the Secretary of State for Energy Security and Net Zero when looking at the Section 13 Climate Change Act part of things.
You said the last thing again, sorry. Also
by the Secretary of State for Energy Security and Net Zero, because that's what the Commission return is directed.
Yes.
So then the question is, well, what more do you need to do by way of rationality as Secretary of State for Transport and a planning decision when all of this has already been looked at and considered by government to be an acceptable way to get to...
And of course, the Section 13 duty on that Secretary of State is a continuing duty.
Yeah, it's a continuing duty.
Well, that's the whole structure of this policy framework. It's an iterative process with the use of carbon budgeting, amongst other techniques, to achieve the end of neutrality in 2050.
And I'm not saying that global feedback finds as its ratio that the Secretary of State for Transport must not ever look at the delivery risk to carbon budgets. What I'm saying is, in circumstances where global feedback says that duty is a duty on the Secretary of State for Energy Security and Net Zero, there's no sectoral legal effort share or anything like that that was being discussed this morning. In circumstances where that's the legal framework, of course it's rational for the Secretary of State for Transport to say that's being looked at by someone else, it's properly to be looked at by that Secretary of State, because that's the legal framework. So I don't have to second guess that. I don't have to go off digging into my Commission return to analyse delivery risks that I'm aware of in general terms.
But I thought you were saying, although the Secretary of State, this Secretary of State can rely upon the Section 13 regime functioning, nonetheless, a review was being carried out by this Secretary of State in relation to her own policies.
Yes, that too. So there's two strands to that. There's one, you can rely on Section 13.
See page 474, I think is the page you place particular reliance on.
Yes, but two, on the facts, actually, the Secretary of State was looking at her own non-planning policies anyway,
Yeah.
and keeping them under review and monitoring them to keep on track for Jet Zero aviation by 2050. So then on to the two documents and what it is they're said to show. And why it is they're said to be something you had to take into account as a matter of rationality or ES adequacy. The 1 year on modelling is at tab 14 of the supplemental bundle at page 158 to 159.
page 100
58 to 159 is AF's deadline 6. So that's what they were saying about what this modelling showed. And they've got 2 points.
We've got the modelling somewhere, haven't we?
It's right behind this page. It's on page 160 is the...
So we know what,
yeah.
we know what they're talking about.
You know what they're talking about.
Modelling at 160.
So it came to AEF by way of a Freedom of Information Act request. So they, I think, exerted some of it into the document itself on page 159. And then you have more of it on page 161 and 162.
What they're doing, I think, at page 159 is extracting information from the department's document.
Yeah, that's exactly right. And the point that we rely on is that, in addition to my main point that all of this was before the examination and dealt with in the examining motion report and referred to by way of cross-reference in the decision letter.
So sorry, so that I'm clear about. So this particular document, the information request, was what the panel were referring to when you took us to the earlier passage.
This being a deadline 6 representation in the examination. Yes, I think Mr. Hall managed to drum this into me this morning.
And the points being made is that the GAL couldn't rely on Jet Zero to manage climate impact because the emissions forecasts were higher. The emissions forecasts by the applicant were higher. So in circumstances where the applicant says it's 2x emissions, but we think that could be married by Jet Zero, AF are saying, well, actually, Jet Zero 1 year on only models 1x emissions, so you can't rely on this policy to mitigate the emissions in longer term. And the point that we rely on here is that this was made clear in this document. It's very hard to see, at least in my A5 version, because it's quite small text, is that modelling was very heavily caveated by the department when it was sent out. And it was said that it's not a cap on development, and there's lots of uncertainty when considering results at the level of individual airports. So the department is saying when publishing, providing...
So what's the reference for this?
That's all on page 161.
161, yeah. How about how far down, so we can try and blow this up later?
Yeah. It says, proceed with caution.
Sorry, where does it say that?
Hopefully.
Well, it's under model forecast.
Under model forecast caveats, there are 4 caveats.
Yeah.
Is it all of them, or one particular one that you're referring to?
Number 1 in particular, but we'll please read all of them. Sorry, there's a 5th one because there's a line.
What?
Yeah, at the bottom.
So the fifth caveat is differently spaced.
Yes, but it's there.
But it's
And which is the one you're highlighting at the moment?
The first one.
The first one, it should be noted that there is uncertainty when considering results of the level. I see. So this is when they disaggregate, presumably, results between different airports. Especially, I think I remember reading this before, especially those subject to, it's obviously very popular, subject to high levels of competition. Yeah.
And the 5th one also has a proceed with caution warning to it.
1, 2, 3, 4, 5. So the department's aviation model.
Yes, yeah, so it's about halfway through. It says these airport level estimates should nevertheless be treated with caution, as the emphasis was national level forecasts when undergoing model calibration prior to publishing these forecasts.
So the model was calibrated at a national level.
Exactly.
to data from 2019, it seems.
And the answer to that, as expressed by the examining authority, the DL, is there's enough in the Jet Zero strategy that if there is evidence to show you're off track, that you can get back on track because you've got this regular cycle of monitoring and implementing further measures.
So what's global feedback got to do with any of this?
Global feedback has to do with the commission return, which is my last.
Sorry, it has to do with
the commission return.
Ah.
Which is my last 2 minutes. Of the commission return, you were handed a blown up version of it, so it's SB 275. So as you'll know by now, the background to the commission return is under section 13. It's a continuing duty. There's a regular cycle of monitoring. It intensifies when you're in the business of producing a report every 5 years to Parliament under section 14. So there's a lot of section 13 activity going on in government in the first half of last year, because they were complying with the court order to produce a new report. And there were commission returns along the way. And the one we're looking at is July 2025.
these are annual returns.
They're not annual, they're more regular.
So it was like 3 monthly almost.
At this point in time.
At this point in time.
At this point in time, because they were working on a report, it was January, March, and July. It is about every, this was in feedback, I think it's described in the facts, about every 6 months they do a regular internal check on how they're doing vis-a-vis compliance with section 13. And the key, the bit of the risks that the appellant says the Secretary of State ought to have taken into account are set out in this top line of the commission return, which is very difficult to read. What this commission return is doing is saying, dear Secretary of State for Energy Security Net Zero, you've asked us to produce savings consistent with our effort share. Here is our plan scenario for what we think you can conclude will be achieved. We're also showing you the risks, and then in the third column we're also showing you the steps we're going to take to achieve the model savings.
How much of this document do we need?
Well, we don't get very much because most of it's redacted.
Is it just this is 275, isn't it?
Just this
Is
bit
it just
here.
the boxes at the top?
Yeah. Well, I'm trying to work out, because it's the underneath the policy name. In the larger version, we've got some other strands of policy, but most of it's been redacted. What we have is the 2 policy rows that deal with take-up of sustainable aviation fuels, as I understand it. And the column to which I think you're trying to draw our attention is the key risks to achieving model savings.
And
Is that the
steps
penultimate column?
And the steps to achieving model
savings. So they go together.
Yeah.
What you're doing to enable the Secretary of State for Energy Security to reach a judgment of whether the package will work or not is identifying the risk and identifying the steps you're going to take to mitigate that. And that's the structure of the return. This deals with SAT because that's one strand of Jet Zero, that's one of the policies that goes into the Section 30 analysis. What it doesn't say is Jet Zero is not going to work.
We could have these 2 typed out in Word.
We could do.
Yeah. I mean, when there are problems with bundles, it's quite normal for solicitors to type out the difficult pages and agree the text.
Well, I'm sure junior counsel will be able to extract this page.
Yeah, and put it into a Word document.
Put it in a Word document in a trice.
Yeah, absolutely do that.
It would be helpful.
Yeah. Anyway, do you want? We can read it.
You could be, I don't think you need to read it really for the submissions I make. What is said today in her skeleton by Mr. Holgate is what the Commission return shows, which was relevant to this planning decision, was one, the transport sector as a whole is off track from its effort share. It was explained to the High Court and is reflected in the judgment that the effort share is a planning tool. We talked about this morning. It's a planning tool to help the Secretary of State for Energy Security collect all the policies he needs to make his decision. It's not in and of itself a statutory target, so that doesn't take you anywhere in terms of whether you can rely on the Jet Zero strategy. if that is an argument that we're not going to meet carbon budgets, then that is a global feedback issue, because that is certainly not a matter for this Secretary of State. That's a matter for the Secretary of State for Energy Security and Net Zero. But I don't think that is the argument.
Well, so if you're going to contextualise by reference to the carbon budget, it is a matter for your Secretary of State, isn't it?
Well, no, my lord, because
Not in terms of whether the Section 13 duty is being complied with, and the other duty, Section 8 and so on, but if you're using a carbon budget for contextualising.
so you do, as a Secretary of State for Transport, ask yourself,
Yeah.
the quantum of emissions put me
Yeah.
in a position where I might reach the target.
Will make a material impact on our ability to comply. Yeah.
And the rationale for why that's not the case in this analysis
Yeah.
is that it's not so much that it would, and I can rely on these emissions that do exist being managed on an economy-wide basis
Under the 2008 Act.
And so the question is, for what possible rational purpose do you then need to dig into the delivery risk analysis that's provided to the Secretary of State for Energy Security and Net Zero for the purpose of that exercise?
So part of your answer on this ground relies upon what you said in relation to ground one. Because ground one is an attack on the rationality, the logicality of concluding that there's no material impact on the ability to achieve CB6. But you're bringing that, if I follow you correctly, you're bringing that point back in here. Assuming you get over ground one, you're relying upon the fact that this conclusion's already been reached.
So I'm relying on the Secretary of State having said, I can rely on emissions being mitigated in the long term by the Jet Zero strategy.
Yeah, that's the second part of it, but you began the submission by referring to the fact that there wouldn't be a material impact on the ability to achieve CB6.
Yes, so
Or rather, achieve net zero.
Yes,
But
but in fact one should refer to both.
Yes.
Yeah.
and in that
In other words,
analysis,
I've forgotten the paragraph number in AMPS, but it's 5.28. So there's a separate attack on the way 5.28 has been applied here. But if this decision withstands that challenge, you rely upon what's been concluded in the application of 5.28, partly at this point as well.
yes, because the attack levelled at the decision letter is that the Secretary of State irrationally gave full weight to the Jet Zero strategy and the non-planning.
It's not as, in other words, you don't look at this issue in isolation from what's being decided in another part of the decision letter.
You have to look at it all together.
But although this is a return to DESNES for the purposes of carbon budgeting, Section 13, presumably it also informs the reviewing in the iterative process of the Jet Zero strategy.
Certainly, I wouldn't be able to say, without taking instructions, that the precise information is used more than once. What I would be able to say is that risks to delivery of SAF are obviously considered as part of the review of the Jet
I think that's my point. That's that level of that. Oh yes, I'm not being more specific than that, but that's part of what the information contained here is part of that iterative process. Because although this goes off to DESNES, it's about a policy for which this Secretary of State has governance. So, I go back to my point. Where's global feedback here? Why is it got anything to do with this? What seems to be your case is that actually, whatever this document says, whatever is in the one year modelling, is all part of the process, the iterative process of managing the Jet Zero strategy, for good or ill. And that's how, in fact, the Secretary of State will work out these issues.
The relevance of global feedback is that the Secretary of State admittedly did not look at this document when taking the planning decision. And the reason was because this document is produced for the Section 13 purpose. And
Well, the reason was that she relied upon the Jet Zero strategy and your iterative process of policies.
And she looked at delivery risk in another way through her analysis of the Jet Zero strategy and what's in the text of that. So when you ask yourself, did the Secretary of State do enough rationally? She did. But there is a practical point, which is why everyone goes on about global feedback so much, my lord, in this case, is that if you were to require the Secretary of State, every time she makes a planning decision, to go off and look at the Commission returns and analyse delivery risks.
Well, that's a different point. That's related to the rationality exercise.
Yeah,
but I don't see global feedback providing you with some sort of invisibility cloak in relation to the rationality exercise. You still have to think about all of this material and whether or not it does affect the rationality of the decisions, both in terms of the environmental assessment, in terms of Tameside duty, etc., etc.
But what you don't have to look at is delivery risk to carbon, meeting the carbon budget under section. So you're not looking at the package as a whole because that's.
But that's because of your. Because you say that's because of the policy framework. Not and I'm still struggling with why global feedback has anything to do with this. It was a case discreetly about the question of what the Section 13 duty, who bore the Section 13 duty. It does not provide an invisibility cloak for other decision makers who have to address the same kinds of issues. Your submission is the way the Secretary of State addressed those issues in this case was to rely upon her pre-existing iterative architecture of policy, which was part and parcel of the off-stage left architecture of the Climate Change Act, carbon budgeting, climate change committee, etc., etc. But that, well, anyway, I'm still struggling.
But the way we get there is because there is this line of case law where the concept of delivery risk to the way we meet carbon budgets is being relevant to planning decision. And that's where JAWS comes in, that's where the A12 comes in, and where feedback comes in, which is that a decision about whether you're on track or not to meet national carbon budgets is a Section 13.
But that isn't this case. This case is about, is this a material consideration which makes the judgment that your client reached irrational? So it's not a case about, are we on or off track? I don't believe that to be Mr. Hull's point at all.
I think at points, perhaps the Secretary of State understood the point to be more of a we're off track and therefore there's a problem, which is why the Section 13 analysis comes in. Certainly, when looking at the question of was it rational to rely on the Jet Zero strategy, that was all played out in the decision matter. But the existence of the Commission return, which is an internal document, it's not published, and the fact that it's produced for a different purpose, is relevant to the question of whether the Secretary of State needed to, as a matter of rationality, look at this specific document and the submitted issue of it, because she'd already looked at delivery risk in another way. It was more the I think this was also a big debate before the judge below, which is why Section 13 features in the judgment.
Well, I'm disappointed we're boring you.
I took 4 days.
Yes, I think Section 13 featured heavily in the High Court debate. I wasn't there.
You're acquitted of blame.
Have no blood on my hands. But that is where, I mean, that is the position on this delivery risk point, is when we're being told that there's specific information sitting within the department, and you look at it as a question of rationality, enough was done, and it's not arguable that more should be done. And that is the position we take, and that is also what the judge said, which means we don't need to get into all the complicated detail about do you need more emissions from SAF, do you need more SAF, the table you were taken to today, Bob Moran's witness statement. I don't think we need to go there in terms of the technical detail. The point being that enough was done. And that's that. And now I hand over to
Yes, thank you.
Thank you, my lords. I'm going to try and hop through this very quickly because I'm conscious of time. Using my learned friends' nomenclature, starting with the Leeds City Council case, this is an irrationality argument. And to begin, it's worth looking at the precise reason why this issue came up. So, this issue came up because it was requested by Thames Water as a specific construction sequencing requirement to account for the situation where Thames Water could not yet say that it would have capacity, and it would allow it to manage that issue and it bringing forwards improvements to its own system. And if I very quickly take you to Common Bundle 147 at Minded 2 201, so the Minded 2 decision letter, you can see that if you look at the text.
Sorry, can you just give the reference again?
Yes, of course, my lord. 147.
147.
And you can see it on the second half of 201.
Thank you.
So it was a very specific request by Thames Water in specific circumstances. And the framework of Requirement 31 in total achieves this, starting from 31.3. The requirement itself is at Common Bundle 198. Starting at 31.3, what you have is that Gatwick provide a development phasing plan, which gives passenger growth up to commencement of dual runway operation and then 10 years afterwards. Sub 4 then deals with a process for modelling. Sub 5 deals with a dispute about that modelling. 6 requires Gatwick to stay within its forecasts. 7 then requires Thames Water to confirm its position within 12 months. And then 8 provides for the works on the wastewater treatment plant on site to commence if there is no positive response from Thames Water. And it's only at that point that you go forwards and then get your wastewater treatment plant. And what sub 9 deals with is either option. So you've got 9A, which is essentially the fallback case, which is where you then get the capacity practically available to meet the requirements of the proposed development, or 9B, which is actually the standard case, which is where you connect to the Thames Water system. And I say all that because we know then from the decision letter that the terms of this requirement were agreed by Thames Water and Gatwick.
And we know what seems to be taken about B, as I understand it. The focus is on A.
It is, my lord, yes.
And B, as you call it, the standard provision, they confirm their infrastructure can take it.
Exactly.
I mean, technically, they haven't spelt out you must connect, but
precisely, my lord. But both
goes
sides.
Without saying.
Precisely, both deal
Otherwise,
with
you'll have all sorts of pollution problems.
You'd have a statutory obligation, or they would have a statutory obligation to require to, on demand, connect you.
Oh yes. Yeah.
Well, yes. So there's the Water Industry Act position, but there's also a specific provision in this DCO that deals with that. I can take you there briefly, my lord. It's page 191 of the Common Bundle. So you've got the discharge of water provisions here, and you'll see 22.1 deals with a general right to connect, but it's subject to 3 and 4, and 3 actually changes the normal Water Industry Act position. We say this is a specific provision for this case, and Thames Water can apply certain conditions to connection, and indeed can refuse connection. They just have to not refuse unreasonably. So you actually have that kind of situation here, my lord, where, we would say these problems can't actually really eventuate because you have the provisions in Article 22, which are lex specialis. They're specific provisions provided within the DCO. And as I was saying, my lords, you have in the decision letter itself that this was agreed to by Thames Water, Common Bundle 184, DL letter, paragraph 266. It actually starts on the page before at the bottom of 183. And you have the position there, which is it's agreed as between Thames Water and Gatwick. And you'll remember I've already taken you there. This was specifically requested by Thames Water. So Thames Water are essentially saying our concern is resolved by this requirement. You'll then see, my lords, that there's a reference to Cagney's position, and that's to the submissions that my learned friend referred to, where Cagney raised the concerns, which are functionally, again, before you today. And the Secretary of State considered, practically again, the position that would happen here, which was there is time for the machinery in 31.9a to happen, which is there is the time for this EA permitting to be provided. And I refer again to practical position because, of course, my lords, when this wastewater treatment plant is constructed, it isn't immediately needed at full capacity. Capacity ramps up over time, as we see through the DCO documents, as the proposed development is used, and indeed the baseline case for Gatwick was always going to increase anyway. Gatwick would continue to grow. So what we're dealing with here is the practical machinery to achieve the capacity required in a timely manner. And that's really the crux of what's actually provided for here. You have this requirement, which is a construction timing requirement. You have Article 22, and that all comes together to be a cohesive whole, which could be considered by the Secretary of State to be rational. The judge dealt with it essentially in that way, beginning at Bundle 312, Judgment, paragraph 357, and he characterised a particular objection in the Leeds City Council way at 359, which is Bundle page 312. And again, the objection here is the objection Thames Water raised. It's that specific concern that we're dealing with. And then, as you'll be aware, my lords, the Secretary of State, the judge then considered the case essentially put by the appellant today and essentially said this is a fanciful situation. What's been described is once Thames Water have told GAL, or there's been no response, but there's no capacity, they then take the time to build the wastewater treatment plant, they spend the money on that plant, they use the land for that plant, and they make the application. And then when all of that is done, for some reason, GAL would then seek to connect to Thames Water's system anyway. The judge described that as fanciful. It is, we submit, fanciful. And that's to use a fanciful case to try and advance an irrationality argument, we would submit just doesn't follow through. The Secretary of State was quite entitled to see the practical framework was there available to her and to Gatwick to provide capacity in some form, and that was considered sufficient. Conscious of the time, my lords, unless there's anything else on that, I will quickly go to the tailpiece. The appellant's case on this is a rather short point that there's some third unassessed option. And my Lord Dove went to precisely the response that we've been advancing here, which is, well, you have requirement 1.4, and you have requirement 1.4, which says you can't go outside of the envelope for the ES, and that is the Rochdale envelope, the reasonable worst case, the outer limits of this development. Now we say that is enough to control the use of the requirement, but also, as we know from cases like Tarry and Hafren, you've got to read this requirement in context. It's about specifically the provision of capacity. You've got to read it in the context of Thames Water being the statutory undertaker, subject to the Section 94 duties in the Water Industry Act. And you have to take into account the fact that if something else were to be built or required to be built, there would be a normal consenting process for that, and that may require EIA as well. And then finally, just dealing with a couple of points my learned friend made. First, it was suggested that Thames Water don't have the capacity or the understanding to deal with this issue. They requested this condition, and they knew what it said. And this condition is backed by the force of the criminal law, section 161 of the plan.
I think her point was rather what this enabled was some private law type process, which was away from the public gaze, to agree something about which there is conspicuously a public interest, namely the disposal of wastewater?
Yes, I think, well, first of all, it is not, I mean, Thames Water are subject to statutory duties to act in compliance with the public interest under Section 94. There are lots of other provisions, as my learned friend briefly referred to. There's a similar provision for the Civil Aviation Authority to make this kind of tailpiece change. There's others related to the to national highways. These are all standard ways of managing these concerns in DCOs. And so this isn't some kind of secret process. It's a process that practically allows for the smoothing of the edges within what was already assessed, the envelope of the environmental statement. And so there are limits on what can be done here. And I think my Lord Dove asked about the definition of discharging authority. I have got it. It's in Article 2 instead of Schedule 2. I can pass it up, but it simply means the body responsible for giving an endorsement, agreement, or approval required by a requirement. But I can have that handed up if it would assist my Lord. I think that's everything from me, my Lords, unless I can assist any further.
Thank you.
Thank you, my Lords.
Mr. Strawn.
Somewhat inconveniently, the way we divided up amongst myself and my learned junior.
You're dealing with the tailpiece.
Now, learned junior is not dealing with tailpiece, but I haven't got much to say on that.
No, I thought you might be.
Well, I'm going to deal with tailpiece here. But I think that in order to keep the order you've just heard, I'm going to make my submissions, and then Miss Hutton will deal with ground 4, which was the Jet Zero strategy. I hope that doesn't run out of kilter.
We might manage that.
No. So ground 1, very briefly, you recall that's the issue of use of the IEMA guidance and ANPS policy, differences between them. I've only got 2 points to add, and I hope they help. The first is to reinforce the perils of seeking to read the IEMA guidance as if they were statutory codes, or the guidance was some sort of statutory code, and reading it as if one were a lawyer. And the simple point could be illustrated by page 98 of the supplementary bundle, just to reinforce what we said earlier. Page 98 is the guidance, or should be the part we were looking at. So your lordships are taken to page 97, significant adverse, moderate or major, that box on the left. If you look at the top right, SB 98, what a minor adverse effect is described as, the right-hand column. A minor adverse effect, or better, is therefore a high bar and indicates exemplary performance where a project meets or exceeds measures to achieve net zero earlier than 2050. In fact, that definition appears to be slightly different in the purple box, where it doesn't talk about it needing to be earlier. But the simple point is that these definitions within the guidance have a degree of flexibility even within their own terminology. But the Secretary of State opting for a moderate adverse effect in the way she did under the IEMA guidance, but then applying policy, it's entirely consistent with just using it in the guidance form that it suggests. So that's the first point. The second point is just to reinforce the judgment below as to the way it, in our submission, dealt with this issue. Paragraph 210 in Mr. Justice Moll's judgment, which you have in the common bundle, and fortuitously, page 276 of the common bundle, the judgment, paragraph 210, is actually referring to the decision letter 210, so makes it easy for cross-referencing. My learned friend, Mr. Hom, went to this paragraph, but didn't read out the full, and I don't criticise for it, but just ask your lordships to note that what the judge was tackling here, halfway through, a broader judgment which reflected her, that's the Secretary of State qualified finding in decision letter 210, that shortfall will be mitigated in the long term by the policies brought forward in the Jet Zero strategy. And we submit that the judge here is impeccably recognising what's actually stated in the decision letter itself, that even the conclusion on IEMA was a qualified one by reference to that last sentence you'll find in the decision letter itself, because the Secretary of State was talking about the effects being mitigated by the Jet Zero strategy.
Things would get better.
Precisely. So it was a nuance.
I think we picked this up.
So
That's
those are
DL
the
210.
yeah. Those are the 2 points on ground 1. Otherwise, I adopt my learned friend's submission. Ground 3, non-CO2. Again, I adopt everything you've heard from the Secretary of State in that respect. Just a couple of points in case they assist. There was reference to us having taken a pleading point, the interested party, on the claimant's or the appellant's case. It's not so much a pleading point, but actually an important point of substance as to the conflation by the appellant of 2 different things. One was an allegation of excluding non-CO2 emissions from her consideration, the Secretary of State's consideration. And the other is taking them into account, but using a qualitative assessment rather than a quantitative one. And in our respectful submission, the appellant continues to conflate those. We had identified in paragraphs 60 and 63 of the Statement of Facts and Grounds, bundle reference, core bundle reference CB 68 and 69, that the appellant had originally referred to the Secretary of State as essentially excluding non-CO2 emissions. In paragraph 63, similarly, excluding CO2 emissions from her consideration. And it's not a pleading point, but it was that was the allegation then being advanced. The Secretary of State had effectively ignored non-CO2 emissions in the assessment. And that cannot be reconciled with the decision letter, paragraph 177 and paragraphs 206 to 207. You don't need to go back to them. But when you look at those, the Secretary did anything but exclude them from her assessment. She took them into account, and indeed they weighed against the grant of consent. Weight was given to them. Her decision was to use a qualitative assessment, as had been done by the examining authority. That's the first point. The second point is to emphasise how narrow, in reality, the rationality challenge necessarily has to be about whether one needs to do a quantitative assessment. We've given you this in our skeleton. I'll just summarise the points. Cagney, the appellant, itself had accepted that it was lawful for the examining authority to have gone for a qualitative assessment based on the evidence as it stood before them. That's addressed in the judgment below, paragraph 248, and actually in the Cagney submissions to the Secretary of State, supplementary bundle 238. I don't take
Is this the 9th of June 2025?
Precisely. So they themselves are accepting qualitative approach.
So that was a supplemental bundle.
238, page
Thank
238.
you.
And at that time, of course, the examining authority had, for example, the 1.7 multiplier that was being used for other purposes by the Department of the Energy and Net Zero. So the question then became, in light of the appellant's reliance upon the CCC report on the 7th carbon budget and or the EU ETS reporting for airlines, whether it was now irrational to follow a qualitative rather than a quantitative approach. That's really what it boils down to. And in my submission, that is unsustainable, particularly in light of the submissions you heard today. On the CCC report, you've looked at that already, but my learned friend Mr. Holland said, well, it's not a multiplier approach. And forgive me, because I'd assumed that's what the CCC were doing, was applying a multiplier based on the lead document. The lead research document is referred to in the box 7.6.3. You have references in our scoping. If, however, let's just take the contrary case against me, if the CCC in its report is not applying a multiplier approach, then of course they have not, in fact, put forward a methodology for quantitative analysis for a particular project at all.
Well, I think what we're being told is that we've got a graph at 764 and that can be applied.
Well, my lord, that at 764 plainly can't be applied because that is simply a graph which is showing the CCC's approach to a balanced pathway with CO2 and non-CO2 included.
But it's not expressing conversion factors.
It's not giving you any way in which to apply it to an individual project. So, which is why, in fact, I think...
So they might be trajectories which you might try to achieve.
Well, no one's put them forward. The CCC...
No, I'm not saying they should do, but that's what it's purporting to show, is it?
Well, as I understand
a balanced pathway.
They've, all it's showing, I say all it's showing, the CCC have put forward what they would like as a balanced pathway, not government policy. And within that, they put forward CO2 emissions and attribute something to non-CO2 emissions. We had assumed, because if you go back to box 7.6.3 on page 231, 231, there's a box 7.63 dealing with non-CO2 effects. You see the paragraph overall, the net aviation non-CO2.
Really sorry.
Oh, sorry, that's my fault. It's 231 internally. It's 234. I'm so sorry. The bundle. Sorry. 234.
So where do we look on 234?
In the blue box, then there's halfway down. There's overall.
Overall.
And then it says net aviations to warm climate. Bullet point, there is large uncertainty in the warming impacts on CO2. Our analysis follows the method of Lee et al., which is our reference to the footnote 176. And that's the very same research paper that was referred to in the ban judgment previously as the research paper that sets out a range of multipliers, but then emphasises it's very difficult to choose one because it's all temporal, amongst other things, and each non-CO2 impact has a different effect, some positive, some negative. So if the CCC has done something different other than apply a multiplier, then you're left completely in the dark.
I mean, the short point is, if we read through this document at length, do we find any advice being given that this is a tool that can be used for a project, for example, in development, saying if you want to know what the non-CO2 emissions are, this is how you can get at a number, whether it's a multiplier or something else. Your point is that what we're looking at on page 307 is simply their balanced pathways expressed for both CO2 and non-CO2 GHG.
And absolutely, Molly. So you don't get anything for a project-specific assessment, and you certainly don't get a multiplier.
Or even a sector, for example.
Or even a sector, or a multiplier for a sector. And so, in a sense, the submissions you heard from our own friend rather than undermine the Secretary of State's conclusion, reinforce it. How on earth are you meant to take this document as now providing a way of quantifying non-CO2, as opposed to qualitatively continuing to recognise that there will be an adverse impact, which is precisely what she did.
I mean, figure 7.6.4 is about aviation, isn't it?
It is about aviation, so I suppose it's sector specific in that, that's fair, sorry. But it doesn't tell you, it's not project specific. And
That's
it's not purporting to give
you managed to agree with my lord earlier that...
and that was my, yes.
Yes.
You're absolutely right, and I correct myself.
But But I'm still trying to understand, what is it showing? It's showing balanced pathways. Does it show, even for a sector, the aviation sector obviously, how you get from CO2 emissions to non-CO2 emissions?
My lord, no, other than you could potentially extrapolate, interpolate or extrapolate, whichever it is, from these lines, a potential multiplier that could have been used, but it's quite difficult to do that. Certainly no one's attempted to do that. We've taken...
Well, I'm not sure I follow, because these lines aren't uniform, they diverge.
No, there's a balance. Yes, you're right. But the blue, or I think the blue rather than the black line, is the balanced pathway CO2 and non-CO2 effects. I'm not sure which line that equates to.
In the event, if
CCC
was saying you can use this diagram for that purpose somewhere, there would be some text saying this is what you can use it for.
There's nothing of that kind, and let alone how you then would apply it to, as I said, a project-specific assessment. So the CCC report doesn't materially advance the position so far as the need to adopt a quantitative approach as opposed to a qualitative approach. Well, there's nothing in this document that does. The only other...
To be fair, there's any evidence that was before the High Court explaining this document and how it could be used?
My lord, other than what you've got here...
With just the document?
Yes.
Okay.
Well, I think that's right. I don't recall anything else. And indeed, perhaps more pertinently, to the Secretary of State as well, in the submission being made by the appellant, which the Secretary of State records, that they weren't putting forward.
Well, there's the June 2020, well, this is the point Mr. Justice Mould, I think, made in his judgment. He goes carefully through the sequence of events. He goes through the June 2025 representation to the panel. And what was said, I think it's after paragraph 11, about this additional material, but I think he says that it doesn't address the difficulties which have been previously identified by the panel. Because this was a rather unusual situation, that the parties actually saw the panel's report before the decision letter, because of the need to consult further.
I think it's perhaps...
It's very unusual.
Unique. It might be a unique situation.
Well, maybe not.
But in any event, the appellant wasn't putting forward, if that's right, based on the CCC material, a multiplier to carry out a quantitative analysis. It wasn't advocating for a specific one. Then the other factor that they rely upon is the EU ETS reporting regime, and it's a similar point. That doesn't give you any multiplier or quantitative way of assessing a project. In fact, it's a reporting scheme under which airlines, depending on whether they're large emitters or non, have two different methods for reporting actual non-CO2 impacts based on, for example, the weather on the day, the amount of fuel, destination, time of day, in order to try and, I assume, accumulate data as to what aircraft will assume to have created by way of non-CO2 impacts from an actual flight. That would be consistent with what the Jet Zero strategy is talking about, which is to acquire more data to allow a greater understanding in the future of how these things may operate. But the one thing it doesn't do is provide, let alone scientific consensus, but it's not providing a mechanism for assessing a project of this kind on a quantitative basis. It's not purporting to do that. It doesn't again give a multiplier, for example.
It's a monitoring exercise.
Indeed.
And are you saying that what it does is to say what parameters are to be measured for each flight?
Yes, you've got the document itself, but it tells airlines, depending on your size, but if you're a large emitter, you actually need to give them meteorological conditions of the day of the flight.
But you said also measuring the non-CO2 GHGs.
by measuring them, but you are calculating your non-CO2 impact by reference to meteorological conditions, fuel burn, and different factors. So a reporting mechanism to try and accumulate data, but it's not purporting to quantify prospectively non-CO2 emissions, let alone provide a contextualised benchmark against which you measure them. And that's the third point I just wanted to come to, just in terms of the question of CO2 equivalence. My Lord Justice Dove asked a question about if you take a multiplier, you then might have a CO2 equivalent total. I just wanted to be a little cautious about that. CO2 equivalent for CO2 gases under the Paris Agreement in Kyoto are all about specific types of CO2 emissions, which are then given an equivalent figure, a carbon equivalent, just for...
Is that gases like methane?
Specific gases which have a CO2 beyond carbon dioxide. Yes, I haven't got the list of them.
There's a list of about 6, I think.
Exactly,
How do you
and
guess?
they're listed for the protocol purposes. If you were to convert non-CO2 impacts, and they're not actually gases, some of them are just an impact rather than an emission. It's the creation of a cirrus cloud, for example. So it's not a gas in that sense. I just want to hesitate.
All I was trying to understand was, is it or isn't it an attempt to try and derive a currency, if you like, of climate change potential?
It would be an attempt to do that, but the reason why there's been such difficulty doing it is because when you come to think about equivalence, it's very difficult to make an equivalent assumption. The example being CO2 emissions, you convert them into an equivalent, but they're assumed to be present in the long term, the long-term effect. A non-CO2 impact has a variable, depending on what it is, has a variable effect, depending on the nature of the impact and its duration. So converting that into an equivalent to create a sort of benchmark for both is going to be highly problematic. It doesn't arise so much for CO2 emissions because you know for the long term they're harmful. But how do you convert a temporary non-CO2 impact into the same equivalent as a CO2 impact? These aren't matters for me, for the courts in my submission, but they're just exposing the difficulty which is inherent in all these documents and why no one's been able to come up with a quantitative analysis or proxy to allow you to do this beyond multipliers which have been rejected in the past. Trying to put all that in the context of rationality, is anything that the Secretary of State's done irrational in our submission? No. There was one reference, I hope this helps for the court, was just about the question of the precautionary principle. There is a discussion of the Supreme Court's decision in Friends of the Earth at paragraph 227 of the ban judgment, page 1004, 1005, where the Supreme Court was dealing with the application of the precautionary principle to non-CO2 emissions in the policy. All about whether it's got room to operate. And I'll just give you that reference. The only other, last point, round 7, wastewater treatment. I adopt my learned friends submissions. There was discussion in the court below about the cost of the wastewater treatment works in the order of £40 million. And that's why the judge was referring to the fanciful notion, you build it but don't use it. And the second point is on the tailpiece point, paragraph 33 of the Hubert judgment to which reference was made, page 370 in the bundle, deals with the Mid-Counties principle to, in that particular case, the tailpiece would allow the turbine to be increased in size up or down. Nothing of that kind is possible under this tailpiece because, of course, adjustments in terms of the wastewater treatment works or indeed any other form of development would require consent. So, for example, the wastewater treatment works is fixed by the DCO plans. If someone proposing some other form of development, it's going to be outside the scope of the DCA, it would require its own consent. That's a very different tailpiece to the one in that case. Unless I can assist that.
My Lord's, ground 4, I adopt the submissions of my learned friends Gregan and those that are in our skeleton argument. The short point, my Lords, is there can be nothing irrational in relying upon up-to-date government policy in the assessment of emissions, or indeed by the Secretary of State in her decision. And that is particularly the case where that policy itself has within it mechanisms to address risk. And your Lordships have been taken to Jet Zero, and the point that I would emphasise that it is a commitment to a trajectory. It is not the government saying what they think will happen. It is a policy commitment to a trajectory with review mechanisms in order to ensure that trajectory is met. It, of course, sits within the context of the Climate Change Act 2008. And this is coming to the global feedback point raised by Lord Justice Dove. It sits within the context of the absolute requirement on the Secretary of State for Energy Net Zero to set and meet carbon budgets. And that is the tenor of the Secretary of State's decision at paragraph 166. My Lord, the ground with regards to the Jet Zero modelling is based upon a fundamental misunderstanding of what Jet Zero 1 year on and its modelling is doing. One year on is looking at, well, how is Jet Zero doing? It does not change the Jet Zero strategy or any of the projections, for example, for sustainable aviation fuel or any other measures. There was modelling, but as your Lordships have seen, it's heavily caveated. And my Lords, at paragraph 46A of our skeleton argument, we've typed out some of those caveats.
Thank you.
But the big point, my Lord, is that they were then calibrated at a national level, and there was a health warning with regards to relying upon them for any individual airport. And my Lord Justice Dove in the Dawes judgment dealt with the modelling for the underlying Jet Zero.
Did I?
You did, my Lord. If I can give the references, and I'm mindful of the time, it was a challenge to the Manston DCO decision, and a challenge was made that it was irrational to find that the climate change impacts were neutral, particularly because Manston had been left out of the modelling for Jet Zero strategy. And that's at Authorities Bundle 29, starting at page 1061. And my Lord Justice Dove, what you said at paragraph 101 was one needs to take the modelling in context. It's not intended to prejudge the outcome of planning decisions, but it is a tool to assess the validity of the policy. And that's page 1078 of the Authorities Bundle. And at paragraph 104, the court found it was permissible to rely upon the Jet Zero strategy and give neutral weight to climate change. So I would rely on that reasoning in terms of the health warning that comes with this modelling. The modelling is not the government saying this is what has to happen in order to meet our trajectory. Rather, the trajectory is set, and then there's a commitment to that trajectory. But look, also the modelling itself, how on earth can it be irrational to not have regard to modelling which actually doesn't tell you anything about the proposal? So the appellant's big point is that, well, Gatwick was left out of the 1 year on modelling. This expansion wasn't included in that. That modelling tells you, therefore, nothing about this expansion. It's doing a completely different job. It's looking at DFT forecasts at that point, simply looking at whether Jet Zero can be delivered. Well, similar issues with the Commission return. The basic point that is pressed on you today is particularly that the delivery return was saying, well, we need more SAF. We're projecting reliance upon more SAF than Jet Zero is. Well, my lord, if that's right, then the appellant's case must be that the ES should have accounted for higher levels of SAF being taken up, i.e. fewer emissions. So it's a very odd point to make in my submission, that that was somehow a mandatory material consideration. But my lord, in any event, there's nothing in that Commission return which could enable this court, or indeed could have enabled the High Court to conclude that Jet Zero was somehow off track. It relied, and I'm not going to, particularly in view of the time, go into the detail of that. Turning to the ES, the ES is, of course, its adequacy is a matter of judgment. Well, look, the appellant is wrong to assert that it relied upon Jet Zero's strategy for its cumulative assessment. And if I could just take your lordships to the reference, it's supplementary bundle 143. Cumulative effects, and my lords will see it paragraph 16.10.3. 16.10.2, an explanation of why for greenhouse gas emissions one doesn't take a typical approach, but compares against carbon budgets. 16.10.4. And then 16.10.5, making clear that the primary approach was the comparison of emissions against carbon budgets. And then as a secondary point at 16.10.6, simply making the point that the appraisal of the aviation emissions had been compared to the Jet Zero strategy underlying data sets and analysis. And so making a secondary point there, but the primary point was a comparison with the carbon budgets themselves, and one can see that on page 141 of the bundle, which is the table setting out the proportions. But my lord, the overarching submissions that cannot be irrational for an applicant to rely upon a trajectory which the government has committed to, and that's particularly the case given it's backed up as the backstop of the Climate Change Act and its legal obligations. And, my lord, it's particularly the case given the fact that at any snapshot of time, various measures under the Jet Zero strategy will be performing differently. So it's inevitable that predictions in the Jet Zero strategy will not be met exactly in every year and for every measure. And my learned friend Ms. Grogan explained that the Commission returns are done at least every 6 months. It would be absurd and unworkable to suggest that the Secretary of State must cast around for what's been done in relation to the Commission returns, notwithstanding it's all done on different modelling and different bases to the Jet Zero strategy, and then potentially seek an update to the ES and her decision making, particularly in an application like this where there was a 2-year decision making process. So the application was made on the 6th of July 2023, and the decision was taken on the 21st of September 2025. So there could have been any number of Commission return exercises during that period, but the effect of the claimant submission, of the appellant submission, is that the Secretary of State must cast around for additional information in relation to a different process, and then potentially require updates to the ES. But that would, in my submission, result in a merry-go-round and would be wholly unworkable. My lord, I've been handed one additional reference in the Dawes case. If I could just give it to you. It's paragraph 104 and 105. Just to draw to your attention, that would be on page
1079.
1079, exactly. apologies, I didn't draw that to your attention when I was dealing with that case.
You did mention 104.
I did mention one. I wonder if I can just check. Well, thank you very much.
Thank you very much. Thank you. So we turn to Mr. Hon for a reply.
My Lord, I'm very grateful. If I may just compile some property here. Oh yes, can you do that in the meantime? In the meantime, can we hand up? Rather than wait for the joys of electronic delivery, we've written up the references
That's very helpful.
so that you've got them.
Thank you.
I'm very grateful. So I'll also deal with the grounds in chronological order. Starting with ground 1, the Secretary of State began by emphasising that IEMA is a practical guide aimed at those in the business of preparing and drafting environmental statements, but I'm not really sure quite how far that goes, because if the Secretary of State is explicit, as she was here, that she has applied the IEMA guidance, then the point stands. Indeed, the Secretary of State was, as we understood it, explicit about that. Look at SB 279, I hope. Yes, which is in the pre-action correspondence. So it's SB 279 in tab 23 at little c. The second point made by the Secretary of State was that the IEMA guidance is a spectrum. She said that was part of the answer, a multicoloured spectrum. And this is quite an important reply point, because my response to that is that the way she put that was too widely framed.
It was my fault because I used the word spectrum. So you tell me what the right answer is.
Apologies. Well, if your Lordship can take up the IEMA guidance. So we're back in, earlier up on this supplementary bundle at page 97.
Sorry,
Page 97.
Thank you very much.
Right, to the extent that there is a spectrum, it is a constrained spectrum. If you
We're
see
on 97.
97.
Whereabouts?
So under the diagram,
Yep.
on the left-hand side, there are 2 paragraphs.
Yes.
Can I just ask the court to read those paragraphs?
Yeah.
So whatever the extent of the spectrum for a significant adverse effect from moderate to major, the IEMA guidance makes it clear that you only get into that ballpark if the project follows a business as usual or de minimis approach and is not compatible with the UK's
Yeah, well,
net
we've
zero
got the
trajectory.
point. There are degrees of compatibility,
Yes.
non-compatibility.
Yes, and that's the difference between a major and a moderate is the degree of compatibility.
Yes.
But what one cannot do and say that's fine because it's a spectrum is find that there is compatibility with the net zero trajectory and a moderate adverse significant effect. And that's effectively what has happened here, because the Secretary of State said that her position was that she doesn't use the word compatible or incompatible, And if she is saying that the project is compatible with the net zero trajectory, then that is fundamentally at odds with the finding that there is a moderate significant adverse effect. That can't be the correct reading of the decision letter. Saying that something is not fully contributing to the net zero trajectory because it's mitigated over time is bound up with the moderate significant adverse effect finding.
I think we understand this.
I'm grateful.
That's box 3.
That's box 3. But what was said was, one must be careful not to give a too literal reading to the IEMA guidance. And my response is that it is not a too literal reading to actually apply all the words and what they say on their face. And if by that the Secretary of State was effectively conceding that if you do apply a literal meaning of IEMA, i.e. you read all the words and apply them, that the problem arose, then we get permission on ground 1 and why sufficient. You only get to a multicoloured spectrum sufficient for the Secretary of State's argument in response to this ground to be effective if you are ignoring some of the words in the IEMA guidance. The Secretary of State then referred to Boswell, and my submission on paragraph 70 was a bit rushed, but I hope I did say, because it was in my notes, that one reads 68, 69 and 70 together. 68, 69 and 70 together. And in my submission, when you read all those paragraphs together, it's clear that the court in Boswell understood that if you are applying the IEMA guidance as your methodology for assessing the significance of climate effects, you cannot simultaneously conclude compliance with the net zero trajectory for the purpose of government policies and a significant adverse effect in IEMA terms. And the fact that the reasoning in Boswell was effectively the kind of opposite route from the reasoning here, but it's by parity of reasoning it still stands. The fact that Boswell was dealing with a different policy statement is irrelevant to that. That's really the only reason that was relied on by the judge to distinguish Boswell. Just for your note, that's paragraph 211 of the judgment on page B276. And that's not a reason that holds water. Finally, in relation to the contextualisation by the CCC against the balanced pathway, that's different ground. That shouldn't be there. But it is the ground I'm going to move on to, unless there are any questions in relation to
Thank you.
ground 1.
Very clear.
On ground 3 then, the Secretary of State said that no part of the EIA regulations purport to require that a quantitative or qualitative rather than a quantitative analysis is required. And that is why I kept emphasising, possibly too much for your Lordship's taste, that the Secretary of State herself identified.
I'm a glutton for punishment.
What the precautionary approach was. We don't rely on the regulations doing that, we rely on the Secretary of State having identified it as the precautionary approach. The Secretary of State then said, well, non-CO2 emissions are more short-lived. And that is right, but not an answer. So paragraph 34 of Cagney's skeleton argument, which is on page 8, makes clear that no matter how short-lived they are, there's no scientific uncertainty that non-CO2 effects are the greater emissions from aviation. Roughly 2/3 of aviation's historical climate impacts likely to be around 3 times that of CO2 emissions. And the references there in the skeleton make that good. So short-lived or not, this is a situation where likely the largest aviation impact in a project in which the largest climate impact was from aviation was dealt with in a small qualitative analysis in the environmental statement, rather than being quantified when the Secretary of State identified that quantification was the precautionary approach.
I seem to remember warming effect is used in order to derive conversion factors between one type of GHG and carbon dioxide.
Yes.
But I think the point you're making is it's only one of the factors.
Correct.
Which explain the differences in the way these gases behave.
Correct, and your Lordship is of course ahead of me. My exact next point is that the CCC methodology uses this global warming potential approach, so the 20 years versus 100 years, in order to address exactly that. So the difference between long-term CO2 and shorter-term non-CO2 is dealt with in the methodology.
Sorry, in which?
In the CCC's methodology. That's the bit under the graph.
Okay.
The BAM case was the next port of call for the Secretary of State, which the submission was that it endorsed qualitative as rational. That's not an answer, we say, but in particular what I wanted to, for the reasons that are already given, I don't need to go over them again, but what I did want to draw the Court's attention to in the BAM case was what was said about the precautionary principle. If we could just take up in the authorities bundle page 1005 in tab 27, so that's 27, 1005. And this paragraph was brought to the Court's attention. And my submission is it's a very curious paragraph indeed. Because suggesting that the precautionary principle is capable of being invoked where the nature of decision-making leaves space for it, in my submission, it's difficult to square with the fact that the EIA regulations are underpinned by the precautionary principle. So there is plainly space for it, particularly where there is disagreement about the correct approach to quantifying and assessing the largest aviation impact. And so this is, if I could just say maybe three more things about the precautionary principle. First, in relation to the precautionary principle, it's not just the, quote, best scientific evidence bit that I mentioned in Wyatt. You might recall that I also said that Cagney had referred to Afton Chemical and the environmental.
Sorry, can you say that again? Not just Wyatt, but
not just Wyatt,
but also.
You might recall that I said that Cagney had referred to Afton Chemical and the environmental principles policy statement. Can we look in the supplementary bundle, please?
The environmental principles policy statement is that under the 2021 Act?
Yes.
Yeah.
In 240, so SB 240. So it's in number 13, SB 240. You see footnote 3. That was, we said, a neat summary of the proportion.
Oh, these are the 9th of June submissions.
Yes, the 9th of
Famous
June
ones.
submissions.
And it's
Footnote 3, which refers to Afton Chemical, which is the usual one, which is the general precautionary principle. Then there's the reference to best scientific evidence. But then it goes on to say that waiting to achieve scientific certainty could increase the risk of damage occurring or could worsen the potential damage.
Yeah, I find that it's not a very helpful statement. That is scientists don't like certainty.
No.
Every time you get a medical report, they just you won't get certainty.
No.
So obviously you don't wait for it.
No, quite.
You might wait for something else. less
No.
than certainty.
No, but
Anyway,
well, or certainly even scientific consensus, which is what the judge has relied on.
well, that's a different concept.
Yes, that is a different concept.
Yeah.
But equally, one doesn't need scientific consensus before taking the type of action that we're dealing with here. Third, what does the precautionary principle require here was one of the questions that was effectively being discussed. And it's not just a question of saying, well, if there's an adverse effect, if there's a question about whether there will be an adverse effect, you assume there'll be an adverse effect. That's the precautionary principle. That's effectively what my Lord Justice Dove was talking about in relation to the hand tax cases. But here there is not a debate about whether one must assume that whether there's an adverse effect or not. The context of this debate is the environmental statement obligation to identify, describe and assess an adverse effect that everybody agrees will arise, and the debate to which the precautionary principle applies is between qualitative and quantitative. And the Secretary of State herself gave the answer as to what the precautionary approach was. That was quantitative, and that wasn't done. It's not enough in my submission, and this is, I finished with what the precautionary principle says, but I've gone on to the decision letter because my own friend, the Secretary of State, emphasised decision letter 178 and said, well, she had the precautionary principle in mind, and in my submission it's not enough to have the precautionary principle just in mind. If you've identified what it requires, then you should require that to be actioned. Then there was the set of submissions where the Secretary of State was just trying to do the best she could, and she took into account that there wasn't a benchmark, or it was difficult to contextualise, and I gave all the submissions about how that's different from what was done in the socioeconomic benefits analysis. But the answer that there is a way to contextualise against the balanced pathway like the CCC did. The Secretary of State's response was, well, the government hasn't accepted that approach. But the mere fact that the government hasn't accepted that approach doesn't mean that the methodology wasn't available to GAL to quantify the emissions. That's not a reason not to quantify, that's a reason to address how to use the benchmark. On to the interested party. The interested party is a pleading point. My own friend said, well, it's a conflation of two different things. One of the allegations was, and he read it out from Statement of Facts and Grounds, that the Secretary of State was essentially excluding non-CO2 emissions. We don't shrink from that. That's what we said the qualitative assessment did, because it was so poor. But the rest of the Statement of Facts and Grounds, and if I could just quickly run through the references. So it's at Core Bundle, tab 7, page 53 onwards. That's the formulation of the ground. And it's really pages 66 to 68. The grounds go on to say that there was a failure even to attempt to quantify contrary to the precautionary approach. That's paragraph 62. That it didn't identify, describe and assess despite accepting it was methodologically possible to quantify. That's 63. And that it was, there were two standalone errors from the response, the no established methodology, scientific consensus, that's paragraph 64. All of this was pleaded, and the selective identification of one part of the pleading doesn't undermine that. CAGNY emphasised in both its skeleton and its submissions that there was more than one methodology. So this issue about, there's a... essentially, GAL had assumed that there was just a multiplier in issue. That can't be right, or at least they didn't read our submissions if that's what they assumed, because those were the submissions that were made to the Secretary of State. If you're still in the supplementary bundle at 240, you might not be, but if you go up to 239, supplementary bundle 239, at the bottom,
Yep.
That's where Cagney sets out the CCC methodology, the use of global warming potential to convert non-CO2 into CO2 equivalent, and say that's a methodology open to the Secretary of State if it is preferred to the use of a multiplier. That was in the submissions, and it was also in the skeleton, that there's more than one methodology. In fact, we rely on the fact that there being more than one methodology to show that this is a more mature area now. Often in the more mature areas of environmental assessment, there will be a number of methodologies from which to choose. I've got an eye on the time, so there's one more thing I want to say about ground 3, and it's to respond to the interested party. And what the interested party now says, now in reply, in the Court of Appeal, is there isn't a CCC methodology. That is a new point. It has never been claimed that there's no CCC methodology.
Can we cut to the chase?
Yes. Previously, what was said was that there wasn't a new methodology. Had the point been made that there's no CCC methodology, we would have been able to rebut that very easily. Because every CCC report, and this court will know this better than most, comes with an underlying, really long, detailed methodology report. And if you want to understand in detail the CCC's methodology, you can look at the underlying methodology report, which sets it out. I checked. There's a big long box that sets out what the methodology is. It's not before this court because the point was never raised. But if there's concern before this court about whether there is a CCC methodology that could have been applied, we can put in that methodology box. The other thing that my learned friend for the interested party said was, oh, these non-CO2 effects, they're all a bit different and it's really tricky to understand how they can be quantified. But they put in, I think they asked to put in Professor Lee's article. I'm not going to go to, well, I'll give one reference. Supplementary bundle, page 68. That's the beginning of where Professor Lee goes very carefully through each non-CO2 effect and shows how the radiative forcing of each pollutant can be calculated. SB 68. The final thing that my known friend for the interested party said was the CCC didn't say, here's a methodology to use for your project. The CCC would never say, here's a methodology to use for your project. That is a wholly unreal set of submissions in response to a simple point. The simple point is that Gal said there wasn't a credible methodology to use. And the CCC methodology is a credible methodology. It's available to use in the way that professionals will apply a type of assessment methodology which has been applied more generally by a professional body like the CCC. Ground 4.
Okay.
The Secretary of State says this isn't a closed mind case, and that the Secretary of State's position was that she didn't look at delivery risk. She didn't say she was legally prevented from doing that, but it's part of the relevant context. I'd just like to look at one point in the witness evidence to address what the Secretary of State actually did. This is one of the references handed up. It's Common Bundle, page 505, in Miss Matthews' witness statement. Miss Matthew apostrophe S's witness statement. So it's paragraph 20 on page 505. Can the court just read the first 2 lines of that? I mean, read it all if you wish, but the first 2 lines are the key ones.
20, you said?
20, paragraph 20 on page 505.
Thank you.
So saying it's not appropriate and saying that it's not within the remit of the Transport and Planning Infrastructure Unit to look at the Commission returns sounds very much to me like it's saying it's not a matter for them and it's and that they had a closed mind. The Secretary of State then turned to the fact that there were a lot of general statements in the Jet Zero strategy that took account of uncertainty. That answers a different case that isn't this case. This case is not just a kind of Boswell-type argument saying you should reduce weight in general to be given to the Jet Zero strategy. This is a specific situation where a particular set of assumptions were being used to quantify emissions. The Secretary of State had her own evidence calling those specific assumptions into question. And the Secretary of State's officers, not thinking that it was in their remit to look at that evidence, didn't engage with it. The Secretary of State then also took you to the Jet Zero 1 year on document for a number of references and made the point that there are measures in the Jet Zero strategy to keep overall on track. But as I explained in opening, that does not help with the specific numbers. You can't lawfully use the numbers from the high ambition scenario to quantify the extent of greenhouse gas emissions and then insulate that from any kind of examination of the environmental statement by saying, assume the Jet Zero strategy will sort it out, or assume it's all fine because of Part 1 of the Climate Change Act 2008. Those two things are inimical to each other. If you are choosing to use the specific numbers from the high ambition scenario to quantify the extent of greenhouse gas emissions, you open yourself up to examination. And the evidence that's relevant to that is relevant. Both the Secretary of State and the interested party relied on the fact that the Jet Zero 1 year on comes with a lot of caveats. And in my submission, that's not an answer, given that the environmental statement used the Jet Zero strategy as its cumulative assessment, and the Jet Zero strategy is similarly caveated. For your note, that supplementary bundle, tab 17, page 435 to 436. I counted at least 3 of the same caveats being given in the Jet Zero strategy as in Jet Zero 1 year on. And if Jet Zero 1 year on was more caveated, it's because airport forecasts became more volatile, and that's a point in CAGNY's favour. In answer to the question, what does global feedback have to do with Jet Zero 1 year on, the Secretary of State's answer was that global feedback is to do with the Policy Commission returns. That was not the judge's answer. At Common Bundle 298, paragraph 301, the judge's answer was the same applies to Jet Zero 1 year on, and he applied global feedback. And that's the point I made in, earlier, that the Jet Zero 1 year on point is a classic NFU instance. And it's actually quite an important clarification to say that global feedback does not displace the clear line of NFU jurisprudence. Finally, the interaction between grounds 1 and grounds 4 was the point raised by the Secretary of State, but it's not clear in my submission how the ANPS analysis has anything to say about the prior fact-finding exercise of reviewing the environmental statement and determining whether the extent of quantification of the emissions was robust and the cumulative assessment could be relied on. GAL began with the health warning in relation to the modelling, but again, Gatwick decided to rely on it as its cumulative assessment under Jet Zero strategy, so the health warning doesn't really answer the point. Second thing that GAL said was, well, more SAF surely is a point that doesn't really go anywhere because you just model more SAF, but it wasn't just more SAF, it's more SAF that came in a commission return with a serious analysis of high risk that SAF uptake would slip, and or that would be significantly constrained because of things like strong international competition. More SAF with more risk makes the confident use of 10% SAF by 2030 and 22% by SAF 2040 shaky. And that's the point. Finally, on ground 7, on the lead city rationality point and the additional point raised by Mr. Kozelko about Article 22 and restricting the duty to connect under the Water Industry Act, a couple of things. First, that point wasn't relied on by the judge or made in the other party's skeletons, but actually we do, it was in detailed submissions and it was referred to in our skeleton argument. So paragraph 99 on page 25 of our skeleton argument points to where CAGNY in its deadline 4 submissions addressed...
Just give me the reference again.
So it's paragraph 99.
99, yeah.
Yes, on page 25. So it refers to the High Court skeleton and it also refers in its SB reference 150 to 157. That's to CAGNY's deadline 4 submissions. They refer to the right to connect and they address what the correct approach should be. CAGNY supported, in fact, in response to that, Thames Water's request for phasing in relation to the condition. We said that should be controlled by the DCO itself within the condition, but obviously none of that was taken up. In short, Thames Water's duties under the Water Industry Act are in fact a point in CAGNY's favour rather than a point against CAGNY on this ground. Second, the Secretary of State's arguments about the full capacity of the works not necessarily being needed immediately and there being time to sort it out. Well, Dr. Lane made a very clear set of submissions which dealt with that, which is the point of the Leeds City Council approach and a Leeds City Council compliant requirement is that it secures the purposes for which the requirement is needed so that one does not have to assume the goodwill of the parties or assume a commercial driver or assume time being available to sort things out in order to achieve compliance. This is not a trust in compliance scenario, and it's not relevant to the legal error to say that there's a little bit of time available because you're not going to need full capacity immediately. On the tailpiece, the Secretary of State's response was essentially that there are other points in the decision letter where other authorities like Thames Water are required to discharge requirements, such as the Highways Authority or the Civil Aviation Authority, and that's standard DCO drafting. But just because the same approach is adopted elsewhere doesn't mean that it is lawful. Also, it's not lawful, notwithstanding brackets 4, because of the 2 points that Dr. Lane made. Thames Water isn't in a position to carry out that proper planning assessment of materially different effects. But even if one assumes that whatever else is agreed will be within the envelope, the Hubert and Carmarthenshire point of concern was that something that has no public involvement, that has no consultation, that is agreed outside of a process which is really centrally about that, will be what controls this issue, which was crucial to local communities having confidence that a potentially big impact of this DCO was going to be controlled. I mean, because of the tailpiece, Gal and Thames Water could agree together to discharge into Thames Water's assets before the modelling is done. That wouldn't be acceptable, but it's something that could happen. So nothing that was said in response to the tailpiece in my submission addresses the core issue. With significant gratitude for the time
We're very grateful.
been allowed.
Well, we're very grateful to all council, not just, well, I think everyone has said, almost everyone has said something. Both the oral and written submissions have been very helpful. Obviously, we're going to reserve our judgments. We will give them as soon as we can. Ordinarily, the judgment will be eventually handed down electronically. ordinarily, it would be made available in draft for typographical corrections to be made. Because of the position where we're now in at the end of term, we may not do that in this case. We may just go straight to handout.
Let you all have a holiday.
Maybe.
I think we might be tempted to read what you said, my lord, even if we are on holiday.
Well, I hope if you're on holiday, you'll allow your juniors to do it rather than you.
As I said,
They might be on holiday.
we might go straight to a handout.
I'm grateful.
If, on the other hand, it is distributed for corrections, then I just need to remind, particularly those who may not be familiar with the procedure, that it's a contempt of court to make the confidential draft available outside the scope of the embargo. And that's taken very seriously. I'm sure it won't happen. Thank you very much.
My lord.
Sorry.
Apologies.
I hope that the arrangements have worked out.
Yes, no, that's absolutely fine. It's on either way there might be consequential matters
Yeah.
to address. It was just to remind you that the parties might need to find a mechanism.
Well, we can't stop you. No, I mean, if there are matters to address, there'll be matters to address. I don't think there's anything else, though. So. No, there's going to be, we've been given the page references to where the pleading points, as it were dealt with.
You have as well, I believe.
And we're going to get a beautiful version
I
of
think
the.
that's already.
It might
Oh,
be.
so it's already been done.
They've already done it.
Wow.
Very,
It's on it. It should be in your inbox. This
Very-
hopefully
thank
already
you.
clerked inbox.
Look forward to that. Thank you.
All right, table.